To the Bold Today Show, I'm your host, J.D. Houvener, owner and patent attorney here at Bold Patents Law Firm. Today we're going to be talking with a special guest, someone we've been working with for quite a while. He's the CEO of Askland Design, and so he'll be on in just a few minutes here, so I know you're waiting for that. Brief outline here of what we're going to be looking at today. As always, we'll be doing our introduction, my offer for a free screening session, and the copy of this book behind me, Bold Ideas, The Inventor's Guide to Patents. And before I do that, mainly for those that may be watching this for the first time, joining us, I do have a disclaimer here. If you're an inventor, thought leader, I ask you to not share your confidential invention information here in this session. This is not a legal consult. There's no attorney-client privilege, okay? But this is for you. This is for the inventor, someone who's thinking about patenting, wants to just get some questions out there, and interested in learning more about what's involved in the innovation process. And today, more importantly, about product design, whether a prototype or not. That is the question we're going to be answering today. And before we get there, I want to give you a free screening session link. Okay, so if you're ready to go, maybe after listening to this program, or maybe you've already been following us for a while and you want to get started, this is a link right here, direct link to schedule on the calendars of our non-attorney advisors who will screen you, listen to your story, listen about your invention, and see if now is the right time, and to see if it's something that our firm will be able to help you with. And so there's the link right there directly to our Calendly page to get started. And for rewarding you, right, for taking action, I'm going to give you a copy of Bold Ideas, The Inventor's Guide to Patents. It's a PDF downloadable book. It's going to give you the basics on everything from patents, trademarks, trade secrets, and copyright law. So I'm happy to see we've got 4 live viewers on. Hello out there. If you guys are new, please give us a like. We'd love to get a like on our page and share this afterward with your social community. I want this to be a vibrant live environment every week. This is the first time I'm trying the ticker symbol below. I feel like a stockbroker. This is going to be fun. But just to remind you that we're here every Wednesday, 9 a.m. Pacific and noon at your lunch break on the East Coast. And we're available, of course, on our website, boldpatents.com. And if you want to pick up the phone, there is the number right below. Okay, so without further ado, I'm going to bring on our special guest. His name is Eric Askland. Eric, welcome to the show.
Good morning. How are you doing?
So glad to have you. Oh, I'm doing good. I mean, you can see from my shirt, I've got this yellow thing, the sun coming through the window. So it's like we're celebrating up here in the Northwest.
Yeah.
You're down there in kind of sunny California, so you're
probably... we're here in Los Angeles. It's sunny and nice and
awesome.
76 degrees pretty much every day. So gotta enjoy that.
Man. Well, good. So, all right. Well, so the burning question that I get from inventors, that are approaching us and thinking about hiring us, they've got this question right away. Do I need a prototype? How far along do I need to be? What if I have no clue how to make things and I've got the idea? How do I get started? And so I thought, gosh, let's bring on, instead of me just rambling like I normally do every week, I want to bring you on because this is what you do, right? This is part of a lot of what you do. So if you wouldn't mind kind of giving us a walkthrough of how do you answer that question? When a new potential client asks you, when do I need a prototype? What's the right time?
Yeah, definitely a prototype is an extremely useful tool, especially when it comes to handing it off to a manufacturer for production. That is where it really pays dividends because the manufacturer immediately is going to take it apart. They're going to find out how it works. They want to know how each part goes together. And if you don't have a prototype, then you're leaving your manufacturer up to decide how it's going to be manufactured, which is okay. Sometimes it can be good if you have a simple enough prototype or a simple enough idea where it can just be replicated easily. But if you have 2 or 3 parts, multiple materials, it needs to bear weight or, have ergonomics, like fit on someone or work with someone in their hands. It's a lot more complicated. And in order to adhere as close to the vision as the original concept of the inventor, it's really important that you have a prototype because then you are that transition from concept to manufacturing is much smoother. And as a product designer, that's what I help inventors do. Help individuals basically smooth that transition from, if I have a concept, it could be as little as a chicken scratch drawing on a piece on a napkin, right. Or a fully functioning, sometimes I have clients who are building their own prototype themselves. And that can be extremely useful because that makes the transition for me easier. And I can see how their brain works, and I can also see, you know, what's important to them. There's so much you can show when you have more content to give. And I think that's what's really important is the prototype is kind of that the last bit of content you can really give someone to kind of show your idea. And if you're, you know, in a Shark Tank like situation, the prototype is a must, especially if
Yes.
you're going into inventors or any kind of, you know, if you're looking for any kind of funding, then a fully functioning prototype is very important.
Right on. Yeah, and I think as you started explaining it, this is getting clearer in my mind. I mean, there's probably multiple meanings of the word prototype, you know, and
Yeah.
when I hear prototype and someone who's just getting started, they're like, you know, kludging together something, or maybe they're more sophisticated where they actually purchased a 3D printer, right? And they just want to be able to convey, here's the three-dimensional object. Is there sort of a pre-prototype that
Yeah.
you kind of suggest that
Yeah,
they, you know, would
definitely.
need to get in touch with someone like you?
Yeah.
And what does that contain?
That is usually a non-functioning prototype. I actually have an example right here of one that I
Okay.
handcrafted. So this is a purely for looks prototype of an impact drill
Nice. What is that? That looks
as a,
sweet.
as a concept. Yeah, it's an impact drill that I made.
Okay.
And it doesn't work. You know, there's not even a trigger on here, but it kind of gets the idea across to an individual. And that I think is really a valuable tool because you can show it, people can hold it, they can see the scale, the material type, and they kind of visualize it more in their head. From there, that's kind of like the first prototype that I would usually produce for a client.
Yeah.
When it goes further on, it's usually meant to be designed with manufacturing in mind. So that's when you go into a production prototype. And that's really where it makes much more important for things like fixtures and bindings and, you know, how the parts adhere, the internals, you know, if there's electronics or if, you know, there's some kind of mechanical functioning parts, all of that needs to be in the final, you know, production prototype. And that's the one
Right.
that you send to the manufacturer, which they'll take apart, and then they'll send you their product manufactured, you know, your product as a manufactured version of it and send it back. And then if you have another prototype, you can compare the two and see how closely, you know, they adhered to your vision. So that is really, you know, it's really important. And yes, prototypes go through many stages. So usually first edition prototype is usually pretty crude. And I do sometimes for clients, especially if it has a mechanical element, what I call a low fidelity prototype. And that is where, you know, this is where most inventors, I think, start. Is they kind of they grab what they have in the house, they start putting stuff together, you know,
Yeah.
and as long as it, you know, works and shows the idea of the mechanical element or the electronic element, then that's enough, you know, that's enough to really get your idea off the ground. I think it's a beautiful thing to have individuals, especially, you know, trying something new, building something on their own, whether or not they think that they're talented at it or not, you know, and just giving it a shot,
Yeah.
I think is really the best way to kind of start. And if you're coming to Bold IP or if you're coming to me, having that kind of content ahead of time is huge.
Yep. Awesome. Yeah, that's really good. And I sort of battle with, you know, and it's custom in a way. And my advice to inventors as I speak with them, even at the initial consult before they've hired us, and they come from different backgrounds. And so what I generally advise, kind of the, you know, the typical route, what I would like to say is, hey, you know, if you've just got the idea alone, right, you're generally not ready to move forward. And so I tell them, okay, well, if you've got the idea, great, that's awesome, right? Bold ideas, okay. When you're at the point to where you have an invention, okay, and that's where you can actually describe it in such detail so that you could go build it
Yeah.
and put it to use. Okay, that's an invention. And then what I usually tell people is like, well, okay, the next step typically is you've got to prove it to yourself, the inventor, that this is going to work the way you thought it was. And this is, of course, the proof of concept phase. And I think some inventors, not all, are able to do just what you said and kind of put together stuff from their house and convince themselves that, yeah, this is going to work. Obviously, this isn't the most efficient version that I'm ever going to get. And then move forward and either speak with us and at the same time speak with someone like you to help them get to those more refined, non-functional prototypes and the way that it might actually look when it goes to market. But I do speak with some inventors that aren't even comfortable bringing something to proof of concept. They just have no idea how to build the thing, and they want to. Do you help individuals do that, actually get to the proof of concept phase?
Yes. I provided a couple of different packages, and some of them don't include a prototype, but include digital versions of that. So that includes hand drawings and 3D models and design drafts, which is good enough to take directly to a manufacturer and get the part produced.
Yep.
But yeah, I also produce prototypes for them, or I can also outsource to prototypers in China who are more linked closer to the manufacturer. So
Right.
then they can kind of smooth that transition. The element though that I like to, if I really like the prototype or I really like the idea, I really want to build it myself, because then I can ensure that when I send it off, it's kind of being built behind closed doors, and we'll get updates on it. But a lot of the time, a lot of the executive decisions are decided without our consultation. So when I produce a prototype, you're going to see a transparent view of how everything goes together. You're going to learn a lot about product design, and when we produce it, it's going to be as close to your vision or your initial concept as possible. So
Cool. Awesome. Thank you. And I want to, I don't want to take too much more of your time. I do want to make sure we visit your website.
yeah,
And I
sure.
just put that link in there for those that are looking in the comments. So let me share my screen, and I'll just have you kind of walk us through your site, if that's a good place for people to
Yeah.
find you. And it's ashlanddesign.com. So right here on the homepage, what are we looking at?
This is these are booths that I had at a design studio, where I showed off some concepts to some of my fellow friends and classmates. And if you go to projects, you can see these are some of the projects I worked on at school. And if you click on the project Zephyr, the ergonomic mouse, that is a good indication of kind of the process. If you scroll all the way down, I kind of go in length about describing it, but here you can see how some of the creative process from drawing it out really small, and drew it out and then kind of molded it into the shape that I wanted, and then I created it in 3D. And so those are some of the 3D images that I created for myself, and then I created a prototype for it as well. Not a fully functioning prototype, but a first edition prototype, basically. And yeah, it's a lot of fun to build. I usually build prototypes for all of my products, so this was kind of a personal product I wanted to make for a mouse design competition, and yeah, it's a lot of fun.
Cool. Excellent. I like that example. It kind of shows how it goes all the way from idea to iterations and all the way through to, as you said, kind of a first gen functional prototype.
Yeah.
So, well, thank you for joining. I appreciate your time. We may get some more live questions through the rest of the show, so I'd like to keep you backstage.
Yeah,
and
just
then
let me know.
we'll bring you back on and then give you a salute. So thanks for being with us, Eric.
Yes, of course.
All right, cool. Well, thank you. Keep those questions coming. I see Charles gave us some thumbs up and a star there. Thank you for that. And Svet, I saw you put a comment in there about not being able to book with a foreign phone number, which I actually haven't heard of. So yeah, please do send me an email. I would love to get kind of our IT side on board to get you the ability to book. We definitely do have a lot of clients that are overseas that are seeking U.S. patent rights, and we'd love to have you. All right, so let's jump to our next part of the agenda, which is going to be our avo.com questions. And so I looked this morning, and there were 12 trademark application questions. This is a lot. So I'm going to try to get through maybe 3 or 4, and we'll see if we have any live questions. I will prioritize those for sure. Okay, so this first question is out of Coral Springs, Florida. Let me put in this question here so everybody can see it. All right, here we go. So if someone has trademarked wording with an image, can I still use the wording without the image and not be infringing? Ooh, this is good. This is good. Okay. So, all right, there are two main types of trademarks that you can get registered. There are word marks, right, which is the English letters, the words, and then there's design marks, which a lot of people refer to as logos, right? And so this question is asking about a logo. So someone has a registration for a logo, like we do, right? Up in the upper right-hand corner here, you got the BOLD. Yes, it does have those letters, but we actually have a design mark over this. So it's not that it actually has letters in it, but it's just, it's designed with certain colors, and it's got these pointed kind of triangular shapes. That's what's actually protected, is the design. So the technical answer here is if someone only has a design registration, it cannot, by definition, control the English characters. So I think technically, I don't believe you'd be infringing, okay? And this is my casual, off-the-cuff opinion here. What I would want to do is have you send in information about what you're going to market with, right? Send that registered mark, and then send how you're planning to sell goods or services. And we can give you a written opinion that you could actually rely on. But that is my notion. That's the technical law, is that a design mark cannot bestow rights to protect words or letters, right? It's only the design. Great question. Let me jump to this next one here. And this one's out of Chicago, Illinois. So this question is kind of a two-part question. So let me bring that one in here. Again, I haven't pre-screened these, so hopefully they're legitimate, non-obscene questions. Okay, so can I sell a slogan created by me to a company? I created a slogan, nobody knows about it, and it's not registered. Could I sell it? Absolutely. Absolutely. So the way that would work, to get a registered slogan, you have to be able to show to the trademark office that you are using that slogan in commerce. That's one of the trickiest parts about slogans, or if you're just planning to sell or license a mark, is you do have to actually demonstrate and provide a specimen that you're selling, actually providing services or selling goods using that slogan. And the bar isn't that big, right? You've got to be able to demonstrate you've got a website, you're using the slogan, and then show at least one online sale that's interstate, right, outside your local geography. And that'll usually be enough for the trademark office to award a registration. Of course, you got to meet all the other requirements for getting a registration. It can't be confusingly similar to another mark, and it can't be on point. It can't be merely generic to what you're selling. A good example I always give is if you're selling bottled water, if your brand name is water, right? It's just describing the product that you're selling, you're not going to get registration for that. So the answer is yes, and as soon as you get trademark rights granted, that is a legal right and privilege, and as with any other legal right, you do have the ability to fully license, transfer, or sell those rights to another party that's willing to pay for it. So you bet. All right, no more live questions, so we'll just cruise right through to the next one. This is a question out of Los Angeles, California. And again, kind of a little bit of a two-parter. Let's see if this whole question will fit in. May not. Looks like it's a question out of Canada, though. All right. I fill up a lot of the screen here. Okay. Does Canada have, okay, this may be out of my realm because obviously I'm a U.S. attorney, but does Canada have a threshold retail value requirement to post a bond in the sweepstakes? We want to post a sweepstakes in Canada, and I was wondering, excluding Quebec, is there a threshold retail value where we must post the bond? Okay, I don't know. I am so sorry. I'm not a Canadian attorney. Please try to get a hold of one, and if you're struggling to get a hold of one, I could do some research for you on Google, but I imagine you could find one on your own. That'd be important. All right. Next question here. Shreveport, Louisiana. All right. So there's two. Okay, here we go. There we go. All right. Again, this one's kind of long form, so it may not fit in all the different channels. Okay. If the two trademarks are nearly identical, where the first mark is for professional staffing and recruiting services, and the second mark is for providing a freelancer marketplace, like Upwork or Fiverr, how likely is it that there's to be a likelihood of confusion between the two marks? Okay, I got it. All right, so then there's a little bit more here we'll bring in. So the person asking the question, hey, Jim, good to see you. Welcome to the show. Jim DeBetta, all right. We should have you on soon, Jim. Jim DeBetta is a professional who does licensing and helps broker patents and deals all around the country. So it'd be great to have him on. But I'm trying to get a hold of this trademark question here, which is a good one. The person asking the question is a company that, like it says, that they'll not be directly involved in hiring. Let's see, or staffing, but can do it themselves. Will be providing a platform for talent and potential job seekers to meet. Okay. Well, this is a detailed question. This is pretty nuanced. There are separate classes, as you've identified here, one for professional staffing and recruiting, and a separate class for providing a freelancer marketplace. To me, those are very closely related. Okay, I'm not in the industry, and as an outsider, which is a decent, thought. If you're going to be using the same name or the same mark, and you're going for that, I do think there would be some confusion in the marketplace because customers, it's sort of a reasonable likelihood of confusion. It's an objective standard. So that's my hunch answer is yes, I do think there would be a conflict of interest. Sorry, a confusingly similar mark. If you would please send me an email on that, I'll send you a follow-up. I'd love to get some more details on what exactly the mark is and if there's any way to move forward. We have an in-house trademark attorney, even though we are Bold Patents. Anyway, thank you for that question. Sabat's got a question here. To the screening that you're offering, will there be some type of non-disclosure agreement? There is not. Okay, so we are a law firm, and it's one of the great benefits of being a law firm is that we're already sworn an oath to confidentiality. And that's one of the great things about going to a law firm is that anything you discuss must be held in confidence under state and federal agencies. Whereas patent attorneys, we're sworn to both the state and to the national federal level at the USPTO. So you're kind of double covered in terms of confidentiality protection. We will advise you in almost every case, if you're going to be disclosing your invention to a third party, such as a business partner, investor, or a company you might want to try to license the product to, we'll get you in touch with a local state licensed business attorney who can then draft a custom contract, which certainly would include a confidentiality provision, an NDA, and even an IP assignment clause. So good question, Svet. We do get that quite a bit from what inventors are worried about, who they're speaking with. And one more quick note: as an attorney, even if you don't end up bringing, if we don't end up doing business with you, if we don't bring you on as a client, we are obliged to keep all the information confidential. So even if, like I said, if we don't hire you, if you don't pay us any money, anything you share with us is going to be held in confidence. Excellent. Well, Eric, we didn't have any direct questions for you, but I wanted to bring you back on to say thank you for coming on our show and for sharing so much wisdom about prototyping.
Yeah. Don't forget to go check out and get this book. It's a lifesaver,
You've got the version 1, my friend. Show that one again, would you? That might be worth something. Just kidding. No, that's the old version. But yeah, Bold Ideas, the Inventor's Guide to Patents. We did put a new cover on it just a couple years ago, but it's the same goods. And you bet, Eric. It's my pleasure. Yeah. All right. Well, we're going to wrap it up. We'll wrap the show up. We'll be on next week every Wednesday. Please bring your questions, and maybe we'll have Jim DeBetta on too. Thanks, everybody. Take care. Go big, Go Bold.